Kendall, recently the Justice Department had announced a stepped-up interest in looking at individuals in instances of corporate misconduct. The anti-money laundering laws are more about programs that institutions have to have in place. So how does that impact your unit?
So that's a great question, Aruna, and I think it does go to the difference in the legal regime. There's a criminal charge that we can use when talking about misconduct at financial institutions. That is, whether or not the institution has an effective anti-money laundering program. It's a part of the Bank Secrecy Act. In order to hold an individual responsible for breaking that law, you would have to say, essentially, this person caused the institution to be criminally deficient in its anti-money laundering program. So we have used that occasionally, but it tends to be with smaller institutions where you can really attribute all the decision-making to either one person or one small group of people. But the larger an institution, the less likely I think it is that you will have a set of admissible evidence that will lead to that type of a charge. That doesn't say it won't happen, and we're obviously looking for those types of cases. But typically, if it's misconduct at a big financial institution, the individual involved will be involved in knowingly aiding and abetting money laundering itself or committing a fraud violation. So we're not going to be focused on whether or not the institution had a viable AML program. We're going to be focused on, can we prosecute this individual for the misconduct at the bank?
And do you think we might see any more civil cases in this area? That's something that the Justice Department has been paying a lot more attention to.
Sure. No, I think we will. So there was a memorandum put out by the Deputy Attorney General called colloquially the Yates Memorandum. And it included basically several department-wide steps we should be looking at in our corporate prosecutions. One of which was, in addition to holding individuals criminally responsible, that might not always be an option, but there might be appropriate civil remedies which we could pursue. In the past, my colleagues that bring civil cases at the department, one of their mandates has been to focus on maximizing recoveries to the United States. So where were the deepest pockets to bring a lawsuit? But this Yates Memorandum makes clear that civil enforcement can have an important punitive and deterrent effect, just like criminal prosecution. And so my civil colleagues won't now be focused primarily on maximizing recovery, where otherwise the facts might be suitable for a civil enforcement action against an individual.
Would you be worried about anything along those lines?
Well, I think Kendall, he's emphasized the standard of a criminal prosecution, and I think compliance officials understand that. So there isn't a fear of really criminal prosecution for people who are doing what they're supposed to do. There is a tremendous fear of civil and regulatory enforcement actions, which obviously can...
Against institutions or
against
even against
individuals. And historically, those actions have been taken against compliance officers. I think now, with the emphasis by a lot of the functional regulators on what they call the 3 lines of defense, so the knowledge and understanding that the business is as involved and required to be as involved in risk management as compliance, is helping defer some of that concern. But on the whole, usually a compliance officer is the easiest person to make a case against. A civil case against someone in a senior compliance role is generally the end of that person's career, and can obviously have devastating personal consequences for that person and their family, which is, you're talking about people who are serving in these roles, generally have some government background, fighting financial crime and illicit finance. They're people who care about the system, and they're dealing with very difficult issues in a risk-based system, where it's hard to understand sometimes exactly what's gone wrong and what's going wrong at the time, and then it can look very obvious in retrospect. So I would say there is a tremendous amount of fear among compliance people and financial institutions around enforcement, and in fact I think it's impacting people's willingness to accept those designated roles that require particularly enhanced fiduciary responsibilities.